Number 1. Charles Victor Thompson, the death row escapee who couldn't outrun his fate. Charles Victor Thompson was born on June 13, 1970, in Harris County, Texas, a place he would never truly leave behind, no matter how desperately he tried to run from it. He grew up in the Houston suburb of Tomball, and by the time he reached his late 20s, the choices he made in a single violent morning in the spring of 1998 would set in motion a chain of events that would define the remaining 28 years of his life, culminating in a lethal injection chamber at the Huntsville unit of the Texas Department of Criminal Justice on January 28, 2026, making him the first person executed in the United States that year. Thompson's story is not simply one of a man who committed a double murder out of jealousy and rage. It is also the story of a legal odyssey that spanned nearly 3 decades, a courtroom conviction that was partially overturned and then reinstated, a jaw-dropping jailbreak that made national headlines and turned a death row inmate into a strange kind of folk antihero, and ultimately a reckoning that came 27 years, 9 months, and 28 days after the night he decided to return to an apartment he had been warned to stay away from. At the center of everything were 2 people who deserved none of what happened to them: Glenda Denise Hayslip, 39 years old, and Darren Keith Kane, 30 years old, both of whom were shot inside Hayslip's apartment in the early morning hours of April 30, 1998, in what prosecutors would later describe in court as a premeditated, jealousy-fueled execution carried out by a man who refused to accept that his relationship with Hayslip was over. To understand what happened that morning, it is necessary to understand the relationship between Thompson and Hayslip. The two had been in a romantic relationship prior to 1998, but by the spring of that year, Hayslip had moved on. She had a new partner in Darren Kane, and Thompson, by all accounts, was deeply unhappy about it. Thompson was 27 years old at the time, and whatever resentment or possessiveness had been building inside him came to a head on the night of April 29, 1998, when he showed up at Hayslip's apartment unannounced. According to court records, a neighbor called the police after a disturbance broke out at the residence. When officers arrived, they found Thompson at the scene with his face visibly swollen, evidence that a physical altercation had already taken place. Kane, Hayslip's boyfriend, was present. The officer on scene assessed the situation, determined that no one wished to file a formal complaint at that time, and made the decision to escort Thompson away from the property. Before leaving, Thompson was explicitly warned that if he returned to the apartment complex, he would be charged with criminal trespass. That warning was not enough. Thompson left the complex, but he did not go home and sleep off his anger. Instead, he waited. He armed himself with a firearm. And approximately 3 hours after being escorted away by police, as the clock ticked past 6 in the morning on April 30, 1998, Charles Victor Thompson returned to Glenda Hayslip's apartment. What happened next was captured in forensic evidence, witness statements, and the testimony of prosecutors who would later reconstruct the violence in court with meticulous and devastating detail. Thompson did not knock. He kicked in the front door of the apartment, forcing his way inside. He confronted both Hayslip and Kane. According to the account presented by prosecutor Don Wisner, during trial proceedings, Thompson fired 4 rounds into Darren Kane's neck and chest. Kane turned to run, attempting to flee the apartment, and was shot once more in the back. He fell to the floor. Thompson then stood over him, placed the barrel of the gun to the back of Kane's head at the upper part of his neck, and fired a final, fatal shot. Darren Keith Kane died at the scene. Glenda Denise Hayslip was also shot during the attack. She was transported to Memorial Hermann Hospital, where she fought for her life for the next 7 days, before succumbing to her injuries on May 7, 1998. She was 39 years old. Her son, Wade Hayslip, was just 13 years old when his mother was killed. In the years that followed, Wade would carry that loss with him through every chapter of his life, attending the trial, following the appeals, and ultimately sitting in the witness room at the Huntsville unit on January 28, 2026, to watch the man who murdered his mother receive his final punishment. After the shootings, Thompson did not immediately flee the city. Instead, he drove to the home of a woman named Diane Zernia, a confidant, and according to court records and testimony presented at trial, he described the shootings to her in detail. He also contacted his father. These admissions would later become central to the prosecution's case. Investigators from the Harris County Sheriff's Department and the Houston Police Department moved quickly. The physical evidence at the crime scene was substantial. Forensic analysis matched ballistics to Thompson, and witness testimony corroborated the sequence of events. Thompson was arrested and charged with capital murder. In April 1999, a Harris County jury convicted him of the double murder of Glenda Denise Hayslip and Darren Keith Kane, and on April 14, 1999, he was formally sentenced to death. He was 28 years old when that sentence was handed down, and it appeared that his fate was sealed. But the Texas legal system, like all capital punishment systems, is a long and winding road, and for Charles Victor Thompson, the journey was far from over. Thompson spent approximately 6 years on death row at the Polunsky unit in Livingston, Texas, as his attorneys pursued appeals through the state and federal courts. One of those appeals succeeded in a way that neither halted his execution nor freed him, but instead opened a door to a new sentencing phase. An appellate court ruled that during his original trial, prosecutors had unconstitutionally deployed an undercover investigator who had posed as a fellow inmate in order to elicit incriminating statements from Thompson about the murders. That form of covert interrogation, conducted without proper legal safeguards, was found to have violated Thompson's Sixth Amendment right to counsel. The court's ruling did not overturn his conviction for capital murder. The jury's finding of guilt stood. But the sentence, the death penalty itself, was vacated, and the court ordered a new punishment phase trial. This meant that in November 2005, Thompson was brought back to Harris County, placed in the Harris County Jail while awaiting the resentencing proceedings, and given a new jury that would hear evidence and decide, all over again, whether he should live or die. That new punishment phase trial took place, and the jury heard substantial evidence, including testimony from a separate inmate who said that Thompson had admitted to the murders. Without the tainted undercover testimony, the jury still returned a verdict of death. On October 28, 2005, Charles Victor Thompson was resentenced to die by lethal injection. It was a profound legal moment, but what happened 7 days later would overshadow it entirely, and transform Thompson's case into something that had never happened in American criminal justice in the 21st century. On November 3, 2005, while being held in the Harris County Jail awaiting transfer back to death row, Charles Victor Thompson escaped. Not a near escape. Not an attempt. A successful, completed escape from a county jail by a condemned death row inmate in broad daylight, using nothing but ingenuity, nerve, and a remarkable degree of institutional failure by the jail staff. The mechanics of the escape were extraordinary. Thompson had been placed in an attorney visitation room at the jail under the guise of having a legal meeting. Left alone in that room at some point during the process, he managed to slip out of his handcuffs, an act that required either exceptional dexterity or a degree of preparation that investigators would later try to piece together. He had smuggled civilian clothing into the jail, and he changed out of his orange prison jumpsuit and into khaki pants, a dark blue shirt, and white tennis shoes. He also obtained, through means that were never fully explained publicly, a fake identification badge that identified him as an investigator with the Texas Attorney General's office. Dressed in civilian clothes and carrying that fake credential, Thompson walked through multiple security checkpoints at the Harris County Jail, past at least 4 employees who were supposed to detect exactly this kind of breach. And number 2, Cedric Allen Ricks, the night a boy learned to mimic his dying brother's last breath to survive. Cedric Allen Ricks was 38 years old on the night of May 1, 2013, when he committed acts of violence so savage and so personal that they left an entire North Texas community shaken and placed a 12-year-old boy in the impossible position of having to outsmart a killer in order to stay alive. By the time it was over, Ricks had murdered 2 people, stabbed a child 25 times, and fled the state in the victim's own car, calling family members along the way to confess what he had done. 13 years later, on March 11, 2026, he was executed by lethal injection at the Huntsville unit in Texas, becoming the second person put to death in the United States that year. The story of Cedric Ricks is one of intimate partner violence taken to its most extreme conclusion, of a man with a documented history of brutality toward the women in his life who ultimately acted on the most catastrophic impulse of his nature, and of a 12-year-old boy named Marcus Figueroa who found, in the worst moment of his life, a kind of desperate courage that saved him, and then carried him into the execution chamber years later to watch justice be delivered. To understand the full dimensions of what happened on that Wednesday evening in Bedford, Texas, it is necessary to understand who Cedric Ricks was before he became a death row inmate. Ricks worked as a medical assistant, a profession that requires care and precision, qualities that stood in stark contrast to what prosecutors and former partners would describe as a volatile, controlling, and physically dangerous temperament beneath the surface. The most damning testimony about Ricks's character did not come from law enforcement or forensic experts, but from the women who had lived with him. His ex-wife, Hannah Singleton, testified at his trial and described a marriage characterized by extreme violence, recounting to the jury multiple occasions during their 5 years together when she said Ricks had attempted to kill her. Her testimony painted a portrait of a man who had been capable of lethal violence for years before May 2013, a man for whom the attack that night was not an aberration, but an escalation of a long and deeply ingrained pattern. Prosecutors at trial would characterize Ricks as a psychopath, a clinical description meant to convey not a dramatic Hollywood villain, but a man without the empathy or impulse control that prevents most human beings from crossing the final line. By the spring of 2013, Ricks was in a relationship with Roxanne Sanchez, a 30-year-old woman who lived with her 3 sons at the Colonial Village at Shore Creek Apartments on Park Place Avenue in Bedford, a suburb nestled in northeast Tarrant County between Dallas and Fort Worth. Roxanne was, by all accounts of those who knew her, a devoted and warm mother. She shared a love of helping people, which had drawn her to her own career as a medical assistant, and she had built her life around her children. Her 2 older boys, 12-year-old Marcus Figueroa and 8-year-old Anthony Figueroa, were from a previous marriage. She also had a 9-month-old son named Isaiah, whom she shared with Ricks. The household they had created together should have been, in every ordinary sense, a home. But the relationship between Roxanne Sanchez and Cedric Ricks had already turned dangerous before May 2013. Prosecutors would later reveal a detail that reframed the entire crime in chilling terms. At the time of the murders, Ricks was already facing a separate criminal case in which he had been accused of strangling Roxanne Sanchez. Prosecutors argued at trial that the murders on May 1, 2013, were not simply the result of an argument that spiraled out of control. They were, in the state's view, a calculated attempt by Ricks to eliminate the witnesses to that prior assault, namely Roxanne herself and anyone else who could testify against him. The violence that followed was, according to this theory, not passion but premeditation. Shortly after 7 o'clock in the evening on May 1, 2013, Roxanne Sanchez arrived home from a grocery run with her 3 sons. she carried 9-month-old Isaiah upstairs to the third-floor apartment, leaving some of the grocery bags in the car. When she entered the apartment, she encountered Ricks, and the two began to argue. The exact subject of the argument has never been fully established in public records, but what followed was a rapid and catastrophic escalation. As the argument intensified and turned physical, Roxanne's two older sons, Marcus and Anthony, did what any children in that situation might do out of instinct and love for their mother. They tried to intervene. They stepped forward to stop what was happening. That decision, born of bravery and desperation, placed both of them directly in Ricks's path. According to court records and the testimony presented at trial, Ricks grabbed a knife from the kitchen and began stabbing Roxanne Sanchez multiple times. He stabbed her in the neck, the chest, the hands, and the face. According to the Tarrant County Medical Examiner's Office, Roxanne Sanchez died from stab wounds to the neck, blunt force injuries to the head, and asphyxia. She was 30 years old. Her sons watched their mother die. After killing Roxanne, Ricks turned on the boys. 8-year-old Anthony Figueroa was stabbed and cut more than 40 times. He did not survive. 12-year-old Marcus Figueroa ran to his bedroom closet and tried to call police on his cell phone. When Ricks found him, Marcus dropped the phone and grabbed at the knife blade with his bare hands, cutting them severely in the desperate attempt to protect himself. He was thrown to the ground. Ricks held his head down with one hand and stabbed him repeatedly with the other, driving the blade into his head, neck, back, chest, and face. What happened next is one of the most harrowing and remarkable details in the entire case. Marcus Figueroa, bleeding from 25 separate stab wounds, made a conscious decision in those moments of chaos and agony that demonstrated a presence of mind almost incomprehensible in a 12-year-old child. He had heard his little brother Anthony die. He had heard the gurgling sound Anthony made in his final moments. And so, when Ricks paused over him, Marcus Figueroa deliberately made that same sound, mimicking his dying brother's last breath, in the hope that Ricks would believe he too was dying and walk away. It worked. Ricks, apparently satisfied that Marcus was no longer a threat, stopped stabbing him and left the apartment. Marcus, covered in his own blood and the blood of his family, waited until he was certain Ricks was gone, then got up and called for help. Ricks left the apartment, took Roxanne Sanchez's car, and drove north, out of Texas, toward Oklahoma. He called family members along the way and confessed to what he had done, telling them he had killed Roxanne and instructing them to go to the apartment to collect his 9-month-old son Isaiah, who had been left unharmed in the attack. Ricks's confession call would prove to be one of the most important pieces of evidence in the subsequent prosecution, a self-incriminating account delivered in the immediate aftermath of the murders. Investigators and law enforcement were notified quickly. Bedford police arrived at the Colonial Village at Short Creek Apartments shortly before 9 o'clock that evening. What they found at the third-floor apartment was a devastating crime scene. 2 dead, 1 critically wounded child who had somehow survived, and a 9-month-old baby unharmed. Marcus Figueroa was airlifted to a hospital for emergency treatment. He survived. Investigators traced Ricks's cell phone signal and determined that he was heading north across the state line. Less than 3 hours after the murders, officers from the Oklahoma Highway Patrol arrested Ricks approximately 70 miles north of the Texas-Oklahoma border. He was taken to the Garvin County Jail in Oklahoma, where, according to reports, fellow inmates who learned the details of his crime reportedly attacked him. Ricks initially resisted extradition back to Texas, but he was ultimately returned to Tarrant County to face capital murder charges. The case was prosecuted by Tarrant County prosecutors Bob Gill and Robert Huseman before Judge Molly Westfall in the 371st District Court. The trial lasted approximately 2 weeks and presented a comprehensive reconstruction of the events of May 1, 2013, including forensic evidence from the crime scene, testimony from investigators and the medical examiner, and the devastating first-hand account of Marcus Figueroa himself. Marcus Figueroa's testimony at trial was among the most powerful and wrenching moments in the entire legal proceedings. Now a teenager, he sat before the jury and described in specific. Number 3, James Garfield Broadnax, 40 pages of rap lyrics, 2 dead men, and a cousin who confessed too late. James Garfield Broadnax was born in Texarkana, Texas, and was 19 years old in the summer of 2008 when the choices he made on a single night in Garland set him on a path that would consume the next 18 years of his life and end on a lethal injection gurney at the Huntsville unit on April 30, 2026. He was 37 years old when he died, which means he spent nearly half of his entire life on death row, convicted of a double murder that he himself initially confessed to in graphic and explicit terms on television, then later recanted, and which his own cousin would eventually claim, in a sworn declaration just weeks before the scheduled execution date, to have committed himself. The case of James Broadnax became, in the months leading up to his execution, one of the most hotly debated capital cases in the United States, drawing in some of the most prominent names in the American hip-hop industry, raising fundamental constitutional questions about the use of creative expression as criminal evidence, and forcing a national conversation about race, justice, and the reliability of confessions extracted from teenagers who were high on drugs and, by their own later account, did not care whether they lived or died. At the center of all of it were 2 men who had come to a recording studio parking lot in Garland, Texas, on a warm June night and never went home: Stephen Swan, 26 years old, and Matthew Butler, 28 years old, Christian music producers who were targeted by 2 teenagers looking for someone to rob and who ended up being shot dead for $2 in cash and a set of car keys. The story of what led James Broadnax and his cousin, Demarius Cummings, to the parking lot of Matthew Butler's recording studio on the night of June 19, 2008, begins with a stated intention that was as blunt as it was chilling. According to statements Broadnax gave to media following his arrest, and to accounts that emerged during the investigation, the 2 19-year-old cousins had traveled to the Garland area that night with the explicit purpose of robbing someone. In a Fox 4 television interview that would become the single most damaging piece of evidence against him, Broadnax stated that he and Cummings had taken a DART train and were targeting, in his own words, quote, rich white folks. The 2 men arrived in the parking lot of Matthew Butler's recording studio sometime after midnight. Butler was a Christian music producer who ran the studio out of the Garland area, and Swan was associated with him professionally. When the cousins confronted Butler and Swan in the parking lot, what followed was brief and brutal. According to court records, both men were shot with a .38 caliber handgun. Stephen Swan was shot in the head at intermediate range and in the chest. Matthew Butler was shot in the arm, the chest, and in the back. Both men died in the parking lot. Broadnax and Cummings, having committed 2 murders for the purpose of robbery, left the scene with $2 in cash and Swan's 1995 Ford vehicle. Shortly after 1 o'clock in the morning, a man riding a bicycle home from work passed through the area and discovered the bodies in the parking lot. He immediately alerted firefighters at a nearby fire station, who contacted law enforcement. The investigation moved quickly. Broadnax and Cummings were arrested after being pulled over during a traffic stop in Texarkana, still in possession of Swan's vehicle and wearing clothing they had changed into at a relative's house after the murders. Both men were taken into custody, but it was what happened in the days that followed the arrest that would define the legal proceedings for the next 17 years. Broadnax gave interviews to local television news reporters, and in those interviews, he confessed to the killings in explicit detail. He told Fox 4 reporter Ellen Goldberg and others how he and Cummings had gone to Garland that night, how the confrontation had unfolded, and crucially, how he personally had been the one who pulled the trigger. He described shooting Matthew Butler, watching him stumble backward, then shooting Stephen Swan, watching Swan fall, and then begin to rise again, and shooting him a second time in the head to ensure he could not get back up. He described the killings with an effect that disturbed everyone who watched the footage, combining a matter-of-fact account of the murders with what appeared to be complete indifference to the suffering he had caused. When one reporter asked him if he felt any remorse, his response, broadcast to viewers across the Dallas-Fort Worth area, was a cold stare followed by the question, "Do I look like it?" In another exchange, when asked what he would say to the families of the men he had killed, he responded, quote, "Fuck them." He expressed, in those initial post-arrest media appearances, a hope that the jury would sentence him to death. He was 19 years old. Those statements, combined with the physical evidence linking both cousins to the crime scene and the victim's car, formed the backbone of the prosecution's case in the 2009 trial in Dallas County. The jury convicted Broadnax of capital murder. But it was what happened during the sentencing phase that would transform his case from a straightforward double murder conviction into a national legal controversy. Texas law requires that in capital cases, a jury must make a determination about whether the defendant poses a continuing danger to society, a finding legally described as future dangerousness, before imposing a death sentence rather than life imprisonment. Prosecutors, in making that argument to the jury, introduced into evidence 40 pages of handwritten rap lyrics that had been found in Broadnax's possession at the time of his arrest. The lyrics, written by Broadnax in notebook form, contained violent imagery referencing themes of murder, robbery, street life, and drugs, as well as, according to those who reviewed them in full, passages about love and redemption that the prosecution did not highlight. Prosecutors argued that these lyrics reflected Broadnax's true character and demonstrated that he was, in their characterization, a psychopathic killer and a gangster who posed an irredeemable future danger to society. The lead prosecutor told the jury explicitly that, quote, "The root word of gangsta rap is gangster," and compared Broadnax to predators depicted on nature documentary television. During deliberations, the jury requested to review the 40 pages of lyrics not once but twice, returning to them as they weighed whether James Broadnax should live or die. On the strength of that sentencing phase, the jury returned a verdict of death. Broadnax was 20 years old when he was formally sentenced to die by lethal injection in 2009. Broadnax's cousin and co-defendant, Demarius Cummings, was tried separately in 2011. He was convicted of capital murder under Texas law and received a sentence of life without parole rather than death. Jean and Craig Swan, the parents of victim Stephen Swan, spoke at Cummings's trial about their son. Jean Swan described him as a brilliant young man, an engineer and a musician, and said it was hard to convey how talented he had been. The Swan family expressed disappointment that the Dallas County District Attorney's Office had not sought the death penalty for Cummings as well. Cummings maintained at his own trial that while he had been present, he had not been the shooter, and he did not challenge Broadnax's prior confessions. For the next 14 years, James Broadnax remained on death row at the Polunsky Unit in Livingston, Texas, pursuing appeals through the state and federal courts. During that time, by the accounts of those who worked with him, he underwent a profound personal transformation. He found religious faith. He became a mentor figure to younger inmates. He was described by prison officials and advocates as a model prisoner, and he married a British law school student named Tiana Krosnichi just 2 weeks before his execution. He also, in those years, began to walk back his original confessions, claiming that the statements he had made on television in 2008 were the product of severe psychological distress, suicidal tendencies, and the influence of PCP-laced marijuana at the time of his arrest, and that he had not cared about his own life and had in effect talked himself onto death row out of a combination of intoxication and nihilism. In March 2026, just weeks before the scheduled execution date, the case took a dramatic and unprecedented turn. Demarius Cummings, still serving his life sentence, provided a sworn declaration in which he stated unequivocally that it was he, not Broadnax, who had shot and killed Stephen Swan and Matthew Butler on the night of June 19, 2008. In the declaration, Number 4, Edward Lee Busby Jr., the man who became Texas's 600th execution, and the question that followed him to the end. Edward Lee Busby Jr. was 53 years old when he was executed by lethal injection at the Texas State Penitentiary in Huntsville on the evening of May 14, 2026, becoming, by the formal count of the Texas Department of Criminal Justice, the 600th person put to death in Texas since the state resumed executions in 1982. That number, 600, carried a weight of its own, a grim statistical milestone that drew attention to his case from death penalty observers across the country. But the number that had defined Busby's case throughout its long and tortured legal history was a different one. The number on an IQ test, a figure that his attorneys argued placed him firmly within the category of intellectually disabled persons who, under a landmark 2002 United States Supreme Court ruling, cannot constitutionally be executed. The final days of Busby's life were consumed not by debates about whether he had committed the crime, which he had confessed to, and which had never been seriously disputed, but by a constitutional emergency over whether the state of Texas was about to put a man with an intellectual disability to death, a question the Supreme Court ultimately resolved by lifting a stay that the Fifth Circuit Court of Appeals had just granted, clearing the way for the execution to proceed over the explicit dissent of 3 justices and the consensus opinion of experts on both sides. It was a death that came at the intersection of documented cognitive limitation and documented lethal violence, and it raised questions about the administration of capital punishment in America that would not be resolved by the moment Edward Busby took his last breath in the Huntsville execution chamber. The crime at the center of Busby's case began on a January day in 2004 in a grocery store parking lot in Fort Worth, Texas, and ended days later in an embankment off Interstate 35 in rural Oklahoma, with a 77-year-old woman dead in the trunk of her own car, her face wrapped in 23 feet of duct tape. The victim was Laura Lee Crane, a woman whose life had been defined by education, service, and community. She had graduated from Paschal High School in Fort Worth, earned a Bachelor of Fine Arts degree from Sweet Briar College in Virginia, and a Master of Arts from Texas Christian University. She had spent her professional career at TCU, where she served as the director of Starpoint School, a program dedicated to teaching children with learning disabilities, eventually achieving the title of Director Emeritus upon her retirement. She was 77 years old in January 2004, and by all accounts, she was precisely the kind of person whose presence in a community makes it better, a woman who had devoted decades of her professional life to helping children who struggled to learn. Investigators who examined the crime after the fact concluded that she had been selected as a target entirely at random, chosen not for who she was or what she had done, but simply because she was in the wrong parking lot at the wrong moment, and because the 2 people who chose her wanted her car and whatever money she was carrying. The 2 people were Edward Lee Busby Jr. and a woman named Kathleen Latimer, known to those who knew her as Kitty. The exact nature and history of their relationship, beyond their identification as companions at the time of the crime, was explored during the trial, but the essential facts were never in dispute. In January 2004, Busby was 31 years old and Latimer was a willing participant in what transpired. According to prosecutors and the evidence presented at the 2005 trial in Tarrant County, the 2 of them approached Laura Lee Crane in the parking lot of a Fort Worth grocery store, and what began as a robbery became, over the following days, a murder. They took Crane's car, and they took Crane. They used her credit cards and a blank check to rob her of more than $775, making purchases and withdrawals while she was in their custody. At some point during this period, prosecutors established, Crane was placed in the trunk of her own vehicle and the car continued moving. Busby and Latimer drove north, crossing the state line from Texas into Oklahoma. In the trunk, Laura Lee Crane suffocated. The medical examiner's autopsy determined that 23 feet of duct tape had been wrapped over her entire face, covering both her mouth and her nose, leaving her without the ability to breathe. She was found dead in the trunk. Her body was subsequently discovered on February 3, 2004, at the bottom of an embankment off Interstate 35 near the town of Davis, Oklahoma, not far from the Texas border. The duct tape was still covering her face when her body was found. Busby was arrested in Oklahoma City. When authorities located him, he was still driving Laura Lee Crane's car. Faced with the weight of the evidence against him, Busby spoke with investigators and led them to Crane's body. He confessed to the killing. In his account to investigators, Busby described what had happened and, notably, attempted to shift some portion of the responsibility to Kathleen Latimer, telling investigators that Latimer was the person who had pushed him to abduct Crane and restrain her with the tape, and insisting that he had never meant for anything bad to happen to her. That claim of diminished responsibility, that Busby had been led by a more dominant companion, would echo in the legal proceedings that followed. Latimer was separately prosecuted, convicted of murder, and sentenced to life in prison in February 2006. At the time of Busby's execution in 2026, Latimer was 61 years old and still incarcerated in a Texas prison, with a possible parole eligibility date of 2034. The disparity in outcomes between the two participants in the same crime, one sentenced to death and one to life, reflected a persistent and unresolved tension in capital cases involving co-defendants. Busby's trial for capital murder took place in November 2005 in Tarrant County before a jury that heard the full account of Laura Lee Crane's abduction, robbery, and suffocation death. The prosecution presented a comprehensive case built on Busby's own confession, the forensic evidence from the Oklahoma crime scene, the financial records showing the use of Crane's credit cards, and the physical evidence linking Busby and Latimer to the car and to the victim. The jury convicted Busby of capital murder and sentenced him to death. He was formally sentenced in 2005, and the sentence was affirmed on direct appeal. He was transferred to the Polunsky Unit Death Row facility in Livingston, Texas, where he would spend the next 21 years. What followed was one of the longest and most procedurally complex series of capital appeals in Texas history, defined not by claims of factual innocence, but by the persistent and escalating argument that Edward Lee Busby Jr. should not be executed because he was intellectually disabled and therefore constitutionally protected from execution under the Eighth Amendment. The constitutional backdrop to that argument was the Supreme Court's 2002 decision in Atkins v. Virginia, in which the court ruled that executing intellectually disabled persons constitutes cruel and unusual punishment under the Eighth Amendment, and is therefore prohibited. The court in Atkins left it to individual states to develop their own standards for determining which defendants qualified as intellectually disabled. Texas's approach to that determination would become a source of ongoing controversy in Busby's case, and in other capital cases over the years. What made Busby's situation particularly stark was not that there was a reasonable dispute about whether he had an intellectual disability. The dispute was not between one side saying yes and the other saying no. The dispute was between all available expert opinion on one hand, which said yes, he was intellectually disabled, and the state's legal position on the other hand, which argued that prior courts had already rejected the claim and that the matter was procedurally settled. The Fifth Circuit Court of Appeals, in a 2017 ruling, had found that Busby could pursue arguments about intellectual disability in further proceedings. But years of subsequent litigation did not produce a final judicial resolution of the underlying question before the execution date arrived. In the days immediately before the May 14, 2026, execution date, Busby's attorneys filed emergency appeals arguing that he had been denied adequate funding to conduct proper intellectual disability testing, and that newly administered tests confirmed he met the diagnostic criteria for intellectual disability. They argued that both a defense expert and an expert retained by the Tarrant County District Attorney's Office, the very office that was prosecuting Number 5, James Ernest Hitchcock, nearly 50 years between the crime and the execution, and a death sentence overturned 3 times before it finally held. James Ernest Hitchcock was born on April 5, 1956, in Arkansas, the fourth of 7 children raised in a shack in the small town of Manila, in the flat delta farmland of the state's northeast corner. His family was desperately poor, surviving on what they could earn picking cotton in the fields of the Mississippi River Delta. When Hitchcock was 6 years old, his father contracted skin cancer and died, leaving his mother to raise 7 children alone until she remarried, introducing a stepfather into the household who, by accounts that emerged during later legal proceedings, was frequently abusive toward her. It was a childhood defined by poverty, loss, and instability, the kind of background that defense attorneys in capital cases often spend considerable time reconstructing for juries during the penalty phase of trial, because it speaks to circumstances beyond a child's control that may have shaped the person who later stood accused of the worst thing a person can do. Whether any of it explained or excused what James Ernest Hitchcock did on the night of July 31, 1976, was a question that 4 separate juries over nearly 20 years of resentencing proceedings would ultimately answer the same way: no. He was sentenced to death 4 times for the same crime, the rape and murder of a 13-year-old girl named Cynthia Driggers, and on April 30, 2026, nearly 50 years after he killed her, he was executed by lethal injection at the Florida State Prison near Stark, becoming one of the longest-serving death row inmates in American history, and the 6th person executed in Florida in 2026. By the summer of 1976, Hitchcock was 20 years old and had migrated south from Arkansas to Orlando, Florida, where he moved into the home of his brother Richard and Richard's family. He was unemployed, and the arrangement was temporary by design, a way of getting on his feet in a new place. Among the people living in that household was Cynthia Driggers, Richard's 13-year-old stepdaughter. On the evening of July 30, 1976, Hitchcock went out with friends and spent several hours drinking beer and smoking marijuana in the Winter Garden area outside Orlando. He returned home in the early hours of July 31st, arriving back at his brother's house around 2:30 in the morning. According to the initial statement he gave to police after his arrest, he climbed through the dining room window to enter the house rather than use the door, then went to his room. But he did not stay there. According to investigators, what happened next unfolded inside Cynthia Driggers' bedroom. Hitchcock, still under the influence of alcohol and drugs, went to the 13-year-old girl's room and raped her. When it was over, and when Cynthia told Hitchcock that she had been hurt and that she intended to tell her mother what had happened, Hitchcock moved to stop her. She tried to leave the room. He tried to prevent her from going. And then, according to the evidence established at trial and affirmed through every subsequent legal proceeding, he began to choke her. He took her outside the house, where he beat her and continued choking her until she stopped moving. He left her body in some nearby bushes. Then he went back inside, took a shower, and went to bed. Cynthia Driggers was 13 years old. Her body was discovered the following morning. Investigators arrived quickly, and the circumstances of her death pointed almost immediately to Hitchcock. He was arrested and made statements to police in which, initially, he provided an account of what he had done. The investigation established the essential facts: the rape, the strangulation, the beating, and the disposal of the body in the bushes outside the family home. Hitchcock was charged with first-degree murder. Then, in a move that would define the contested legal landscape of the next several decades, he recanted his initial statements during the trial itself and testified instead that he had not committed the crime. He pointed the finger at his own brother, Richard Hitchcock, claiming that Richard was the true killer of Cynthia Driggers. It was an accusation that would resurface repeatedly in the years that followed, fueled in part by later claims from a handful of individuals who said, after Richard Hitchcock's death in the mid-1990s, that they had heard Richard confess to the killing, and that they had stayed silent while he was alive out of fear. A resentencing judge who examined those claims dismissed them as not credible, citing the extraordinary length of time the witnesses had waited before coming forward. No jury that heard the full evidence of the case ever accepted the theory that Richard Hitchcock had killed Cynthia Driggers. The jury at the original 1977 trial convicted James Ernest Hitchcock of first-degree murder, and on the basis of that conviction, he was sentenced to death. What followed was one of the most procedurally complex and legally significant capital cases in Florida's modern history. The first death sentence, imposed in 1977, was appealed through the Florida court system, and in 1982 the Florida Supreme Court reaffirmed it. But the circumstances of Hitchcock's original sentencing hearing had contained a legal defect that would not be remedied for years. The trial judge had instructed the jury that it could not consider certain types of mitigating evidence when deciding whether to recommend a death sentence, a restriction that amounted to a constitutionally impermissible limitation on the defense's ability to argue for leniency. When this issue reached the United States Supreme Court, the court ruled unanimously in 1987, in a decision that became known as Hitchcock v. Duggar and that bore James Hitchcock's name, that states could not limit the type of evidence a defendant facing a death sentence could present during a sentencing hearing. The ruling was a landmark decision in Eighth Amendment jurisprudence, one that ultimately opened the door for resentencing hearings not just for Hitchcock himself, but for an estimated 50 or more death row inmates in Florida whose original sentencing proceedings had contained similar defects. It was, in a profound historical irony, the case of the man who raped and murdered a 13-year-old girl that produced a ruling protecting the constitutional rights of criminal defendants in capital proceedings. Hitchcock's original death sentence was vacated as a result of the ruling, and he was returned to an Orange County courtroom for a new penalty phase proceeding. That first resentencing trial took place in 1987 and concluded in 1988, with a jury recommending death by a vote of 7-5. The margin was narrow, but it was enough. Hitchcock was sentenced to death a second time. He appealed again, and the Florida Supreme Court upheld the second death sentence in 1990. But further legal challenges kept the case alive. In 1993, the Florida Supreme Court vacated Hitchcock's second death sentence and ordered a third new sentencing proceeding, this time on the grounds that the resentencing trial had improperly introduced evidence portraying Hitchcock as a pedophile, and that this characterization had been made a feature of the penalty phase in a way that constituted legal error. A third resentencing jury was impaneled, heard the evidence, and this time recommended death by a unanimous vote of 12-0. The third death sentence was imposed. Hitchcock appealed again. The Florida Supreme Court vacated the third death sentence in 1996 on further procedural grounds, and a fourth resentencing proceeding began in September of that year. The fourth jury, having heard all the evidence in a case that by now was 2 decades old, recommended death by a vote of 10-2. A fourth death sentence was imposed. In 2000, the Florida Supreme Court upheld that sentence on direct appeal, and the United States Supreme Court subsequently declined to disturb it. After 23 years of proceedings, that included 4 separate sentencing juries all recommending death, the legal foundation of the sentence had finally stabilized. Hitchcock remained on death row at the Union Correctional Institution, pursuing further post-conviction appeals for the next 2.5 decades. During those years on death row, James Ernest Hitchcock presented himself to those around him very differently from the image of violence that defined his crime. At his 1988 resentencing hearing, his attorneys had arranged for 8 of his fellow death row inmates to be transported from prison to an Orange County courtroom to testify on his behalf as character witnesses, an unusual and striking legal move. One inmate, Amos Robinson, who was serving a life sentence for his role in a 1983 Pinellas County murder, testified that Hitchcock had bought him tennis shoes when he had none and could not afford them. Other inmates described Hitchcock as a peacemaker on the unit. One man testified that Hitchcock had helped him learn to read. The picture they painted was of a man who, whatever he had done on a summer night in 1976, had spent his years of incarceration trying to be decent to the people around him. Whether that transformation was genuine, or whether it was the performance of a man who had learned what juries and courts wanted to see, was a question no one could fully answer. What was not in dispute was that his crime had remained unchanged across 5 decades. A 20-year-old man had come home drunk and high from a night out with friends, gone into the bedroom of a 13-year-old girl, raped her, and then beaten and strangled her to death to prevent her from telling what he had done. In the final years of his case, Hitchcock's attorneys maintained a claim of innocence, arguing that his brother Richard was the true killer and that James had been wrongly convicted. The advocacy group Floridians for Alternatives to the Death Penalty took up his case, with its executive director arguing publicly before the execution that the state of Florida was preparing to execute a man despite credible evidence that another person had confessed to the killing. The argument centered on the post-death declarations of witnesses, who said they had heard Richard Hitchcock confess before he died in the mid-1990s. Florida courts that had examined those claims over the years had consistently found them unpersuasive, noting in particular that the witnesses had chosen to remain silent for decades and come forward only after the supposed confessor was dead and beyond the reach of legal consequences. The innocence argument did not gain traction in the final appeals. The Florida Supreme Court denied an emergency appeal in the week before the execution. On the morning of April 30, 2026, the United States Supreme Court denied Hitchcock's final appeal without comment. Governor Ron DeSantis had signed Hitchcock's death warrant on March 30, 2026, and no intervention was forthcoming from any court. On the evening of April 30, 2026, James Ernest Hitchcock, now 70 years old, was prepared for execution at the Florida State Prison near Stark. When the curtain of the execution chamber opened promptly at 6 o'clock, his entire body was covered in a sheet up to his neck. He stared at the ceiling. When the warden asked him for a final statement, he delivered one that was brief and cryptic, making no reference to Cynthia Driggers, no apology to her family, no acknowledgement of what he had done nearly 50 years before. He said only, "Just to say goodbye to Joshua, my friend, thanks for all you've done." A man in the witness room raised his hand in response, and Hitchcock lifted his head to try to see. Then the drugs began to flow. He blinked rapidly and took several deep breaths. A minute later, his breathing became shallow and quickly stopped. About 3 minutes into the execution, the warden briefly touched Hitchcock's face and called his name twice while shaking his shoulders. At 6:12 in the evening, James Ernest Hitchcock was pronounced dead. He was 70 years old, and Cynthia Driggers had been 13. Outside the prison, members of her family addressed reporters. Her younger sister, Lynn Cobb, spoke about the girl Cynthia had been, describing her as someone who had added life, fun, and dreams to their family in the 13 years she was alive. Lynn said she thanked God for the strength and courage she had been given across the years that it had taken to reach this day, and that her family would close the door on this chapter while continuing to keep Cynthia's memory alive, with the understanding that life is precious and time is valuable. One of Driggers's cousins, Johnny Meadows, told reporters that Hitchcock had never believed this day would come. He was wrong. Number 6. Andrew Richard Lukehart, the man who killed a baby, threw her in a pond, and had already done it before. Andrew Richard Lukehart was born on April 10, 1973, in Pennsylvania, the first child of Bonnie and Randy Lukehart, followed about a year and a half later by his only sibling, a sister named Jennifer. He grew up in Pennsylvania surrounded by extended family, cousins and aunts and uncles forming the social fabric of his childhood, a background that appeared, on its surface, unremarkable. But the legal proceedings that followed his eventual arrest and conviction would reveal, through the testimony of psychological experts retained by both the prosecution and the defense, a childhood that contained a devastating hidden history. A forensic psychologist named Dr. Kropp, who evaluated Lukehart in 1994 following his first arrest for child abuse, found that he was suffering what the expert described as severe consequences from his own sexual victimization, which had occurred within his own family, and which Lukehart had never adequately processed or resolved. The expert testified that although the victimization Lukehart had endured as a child was not an excuse for his behavior, it was a contributor to a pattern of unresolved anger and emotional conflict that had never been properly addressed. That psychological portrait was introduced as mitigating evidence during the penalty phase of his 1997 trial, and it explained something about how a young man, with no outward signs of violent tendencies toward adults, could direct lethal violence against infants in his care. What it did not explain, and what no psychological framework could fully account for, was why, after being convicted of abusing one baby in 1994 and serving 10 months in jail, Andrew Lukehart had been in the care of another baby less than 2 years later and had killed her. On June 2, 2026, 30 years after he threw 5-month-old Gabrielle Hanshaw's body into a pond in Jacksonville, Andrew Richard Lukehart was executed by lethal injection at Florida State Prison near Stark, becoming the 8th person executed in Florida in 2026 and the 36th executed under Governor Ron DeSantis. The first chapter of Andrew Lukehart's documented pattern of violence against infants began on April 14, 1994, in Jacksonville, Florida, where he was then living. He was 21 years old and was in a relationship with a woman whose 8-month-old daughter, Jillian French, was in his care. On that day, Lukehart shook Jillian French with such force that she sustained a closed head injury that resulted in seizures and permanent visual deficits. Medical examination also revealed that the baby had suffered broken ribs, broken bones in her arm and leg, and a fractured skull, injuries consistent with repeated and forceful physical abuse. When police initially questioned Lukehart, he told them that Jillian had been drowning in the bathtub before he revived her, and that her head injury had occurred when he stumbled and fell while holding her. That account was not credible given the nature and extent of the injuries. Lukehart eventually pleaded guilty to felony child abuse. What happened next was a decision by the criminal justice system that would haunt the case for decades. Despite sentencing guidelines that called for a prison term of between 40 and 67 months, the state recommended and accepted a sentence of just 10 months in a county jail, followed by 4 years of probation. As conditions of that sentence, Lukehart was required to attend parenting skills classes, take anger management courses, have no contact with Jillian, and have no contact with any minor children until he had completed those programs. Jillian's grandmother, who had watched her granddaughter suffer, and who understood what the 10-month sentence meant about the message the system was sending, told reporters at the time that she was angry and that she had always feared what would happen next. She said, in words that proved prophetic, "I was just waiting to hear about something else." she did not have to wait long. Less than 2 years after Lockhart pleaded guilty to fracturing Gillian French's skull, while he was still serving the probationary period of that sentence, and was still legally prohibited from having unsupervised contact with minor children, he was in a new relationship with a woman named Misty Rue in Jacksonville, and Misty Rue had a 5-month-old daughter named Gabrielle. Her full name was Gabrielle Hanshaw, and she was by all accounts a healthy, normal infant, loved by her mother, and known to the small circle of people around her in the way that all babies are known, not yet a person with a history but a presence, a weight, a smell, a small face that turned toward voices and light. She had been alive for 5 months on February 25, 1996, when her mother's boyfriend became the last person to see her alive. Misty Rue had been ill, as had her older daughter Ashley, and on the afternoon of February 25th, Misty was lying down in the bedroom with Ashley, who also was unwell. Around 4:30 in the afternoon, Lockhart, then 22 years old, went to pick Gabrielle up from her playpen. He noticed that she had a soiled diaper. He went to get a clean diaper and some baby wipes, but Misty told him the wipes were in the back room of the house. He took the clean diaper and the baby into that back room. Misty Rue never saw her daughter alive again. What happened in that back room was established through medical evidence, through Lockhart's multiple and shifting accounts to investigators, and through the careful forensic testimony presented at his 1997 trial. The medical examiner who performed the autopsy on Gabrielle Hanshaw determined that the infant had died of blunt force trauma to the head, with at least 5 separate blows having been delivered to her skull, 2 of which caused fractures. The injuries were accompanied by bruising on her hand and arm that had occurred shortly before her death. The medical examiner testified explicitly that the force required to fracture an infant's skull is equivalent to the force of dropping a child from a height of more than 4 to 5 feet, and that this level of force could only have been produced deliberately, with substantial physical effort. The forensic evidence was unambiguous. This was not an accident. Lockhart's own accounts of what had happened shifted repeatedly over the course of his interrogation and the investigation. In his initial story to police, he claimed that Gabrielle had been kidnapped. According to that account, he had driven away from the family home with Gabrielle, stopped at a convenience store on Normandy Boulevard in Jacksonville, and while he was walking toward the store, he heard a noise, and turned to see a stranger fleeing with a baby in a blue blazer. He said he had chased the vehicle, driving at speed, until his car left County Road 217 in neighboring Clay County and crashed. That story mobilized a massive law enforcement response. As many as 50 officers from Jacksonville and Clay County converged on the area, along with K-9 units, a helicopter, and a dive team, all searching woods and ponds throughout the afternoon and evening. Misty Rue, who had called police after Lockhart phoned her and told her that Gabrielle had been kidnapped, spent those hours in agony, not knowing where her daughter was. Investigators quickly grew suspicious. Lockhart's account of the supposed kidnapping changed multiple times under questioning, with inconsistencies that no genuine eyewitness account would produce. The story did not hold together. After approximately 15 hours of investigation, Lockhart led authorities to Gabrielle's body. It was in a pond. He had thrown her there after she died. During questioning the following day, he admitted to investigators that the kidnapping had never happened. He told them that Gabrielle had died after he dropped her on her head and then shook her. He said he had panicked when he realized she was dead and had thrown her body into the water. A later statement provided a different and more detailed account of what had happened in that back room. He said that as he was trying to change Gabrielle's diaper, she would not lie flat, and that he had responded by forcefully and repeatedly pushing her head and neck to the floor. The medical examiner's findings of 5 separate blows with skull-fracturing force made clear that whatever the precise sequence of events, Lockhart had beaten a 5-month-old infant to death in a room at the back of a Jacksonville house, while her sick mother lay in the next room. Gabrielle Hanshaw was found and recovered from the pond by dive team personnel. She was 5 months old. Andrew Lukehart was arrested and charged with first-degree felony murder and aggravated child abuse. His trial took place in February 1997 in Duval County. The state presented the forensic evidence of the 5 skull-fracturing blows, the prior conviction for child abuse against Gillian French, the multiple changing accounts Lukehart had given investigators, and the fact that he had committed this murder while still on probation for the earlier offense. The prior conviction was a particularly powerful aggravating factor. The Florida Supreme Court, in its later review of the case, characterized it as an exceptionally weighty aggravating circumstance given that the murder of Gabrielle Hanshaw had been committed less than 2 years after the felony abuse of Gillian French, and while Lukehart was still prohibited by the terms of his probation from having unsupervised contact with children. A jury found Lukehart guilty of first-degree murder and aggravated child abuse. During the penalty phase, the defense presented mitigation evidence including the psychological testimony about Lukehart's own history of childhood sexual victimization and its unresolved psychological consequences. The jury was not persuaded that this outweighed the aggravating factors. They recommended the death penalty by a vote of 9-3. The trial court followed that recommendation, and Andrew Richard Lukehart was formally sentenced to death in 1997. He was 23 years old. The legal proceedings that followed his conviction stretched across nearly 3 decades. Lukehart and his attorneys pursued appeals through the Florida state courts and the federal court system, raising challenges to the conviction, the sentence, the adequacy of his legal representation, and, in the final stages of the case, a constitutional argument that had nothing to do with the facts of the crime itself but everything to do with the physical condition of his body in 2026. By the time his execution date approached, Lukehart was suffering from deteriorating kidney function that had been worsening since 2023. Medical records showed that on January 24, 2026, he had collapsed on death row, and that his kidneys were approaching failure, putting him dangerously close to requiring dialysis. His attorneys engaged a medical expert, an anesthesiologist who reviewed Lukehart's records and concluded that Florida's 3-drug lethal injection protocol created what the attorney described as an extremely high likelihood that Lukehart would experience a prolonged and agonizing death, because his failing kidneys could not filter the execution drugs from his bloodstream at a normal rate. The defense argued that executing a man with kidney failure using the standard lethal injection protocol amounted to cruel and unusual punishment in violation of the Eighth Amendment, and that Lukehart's medical circumstances required either a modification of the protocol or a stay of execution pending further review. The Florida Supreme Court denied those appeals in the week before the scheduled execution date. The United States Supreme Court denied Lukehart's final federal appeal on June 1, 2026, the day before the execution. Governor DeSantis had signed Lukehart's death warrant on May 1, 2026, leaving only 1 month between the signing of the warrant and the execution date, a timeline that Lukehart's attorneys also challenged as a denial of due process, arguing that it was insufficient time to pursue meaningful legal remedies. That argument was rejected as well. On the evening of June 2, 2026, Andrew Richard Lukehart was prepared for execution at Florida State Prison. He declined a last meal. He received no visitors before the execution, though he met with a spiritual advisor. A priest sat at the foot of the gurney and prayed over him as the execution was carried out. When the curtain of the execution chamber rose at 6 o'clock, Lukehart was already strapped to the table with an intravenous line in his arm. Gabrielle Hanshaw's mother, Misty Rue, was present among the witnesses. She had told reporters in the weeks before the execution that she planned to attend, and she did, though she declined to make a statement afterward. When the warden asked Lookhart if he had a final statement, he raised his head to look at the group in the front row of the witness area, and he said a single word, "I'm sorry." He then recited the biblical verse from Luke chapter 23, verse 34, the words attributed to Jesus Christ during the crucifixion, "Father, forgive them, for they know not what they do." He lost consciousness almost immediately after the lethal drugs began to flow. At 6:19 in the evening on June 2, 2026, Andrew Richard Lookhart was pronounced dead. He was 53 years old. Gabrielle Hanshaw had been 5 months old. Jillian French, the first baby he abused, had survived but had spent her life carrying the physical consequences of what he had done to her in 1994, the seizures, and the visual deficits that came with a closed head injury inflicted before she was old enough to form memories. The grandmother, who had been angry about the 10-month sentence in 1994, had been right to be afraid. The system that gave Andrew Lookhart 10 months in jail for fracturing an infant's skull had created the conditions for the death of another child. Gabrielle Hanshaw was the price of that leniency, and 30 years later, she was the reason that Andrew Lookhart died strapped to a gurney in Stark. Number 7. Kendrick Simpson, a Katrina evacuee, a baseball cap, a rifle in the trunk, and 2 young men who never made it home. Kendrick Antonio Simpson was born and raised in New Orleans, Louisiana, in the 9th Ward, one of the city's most economically distressed neighborhoods, a place where poverty, street violence, and the near-constant proximity of danger shaped the lives of those who grew up there in ways that left marks both visible and invisible. Simpson's attorneys, in the legal proceedings that defined the last years of his life, described his childhood in the 9th Ward as one of chronic trauma, a formative environment so saturated with violence and instability that it produced, by their account, a case of post-traumatic stress disorder that had never been diagnosed or treated, and that colored every significant decision Simpson made as a young man. That argument was central to the clemency petition his legal team submitted in the weeks before his execution, and it was presented to the Oklahoma Pardon and Parole Board in January 2026 with considerable emotional force and genuine biographical detail. The board heard it, weighed it, and voted narrowly to deny clemency. On February 12, 2026, Kendrick Simpson, 45 years old, was executed by lethal injection at the Oklahoma State Penitentiary in McAlester, becoming the first person executed in Oklahoma in 2026 and the 3rd overall in the United States that year. He died for a crime he himself had admitted to committing, a drive-by shooting in Oklahoma City in January 2006 that killed 2 young men, 19-year-old Anthony Jones and 20-year-old Glenn Palmer, and wounded a third. The trigger event for that shooting was an argument in a nightclub over a baseball cap. The weapon was an AR-15 style assault rifle that Simpson had loaded into the trunk of a car before he ever arrived at the club. The gap between those two facts, between the mundane provocation and the lethal preparedness, tells most of what a jury needed to know about Kendrick Simpson's state of mind on the night of January 15, 2006. To understand how Simpson came to be in Oklahoma City in January 2006, it is necessary to go back 5 months, to August 2005, when Hurricane Katrina made landfall along the Gulf Coast and unleashed one of the most catastrophic natural disasters in American history. The storm flooded the 9th Ward entirely, and tens of thousands of New Orleans residents were evacuated and relocated to cities across the South and Midwest. Kendrick Simpson was among them. He was 24 years old. He had grown up in one of the hardest neighborhoods in the city, and just over a year before the storm, in November 2004, he had been shot 5 times in a drive-by shooting in New Orleans, surviving that attack and carrying the physical and psychological consequences of it into his evacuation. When he arrived in Oklahoma City as part of the broader displacement of the Katrina diaspora, he was a young man already carrying the accumulated weight of poverty, street violence, his own near-death experience in a shooting, and now the total destruction of the city he had grown up in. His defense attorneys would later argue that this history created a specific and documented psychological vulnerability, a PTSD-driven hypervigilance and threat perception that was not an excuse for what he did, but was a context for understanding how a relatively minor nightclub confrontation could escalate so catastrophically in his mind. Oklahoma Attorney General Gentner Drummond rejected that framing entirely, characterizing Simpson as a man who had hunted his victims and shown no genuine remorse, a predator rather than a traumatized young man whose circumstances explained his choices. Both characterizations found their way into the legal record, and the truth of Kendrick Simpson's character was almost certainly somewhere in the complicated space between them. What is not in dispute is the sequence of events on the night of January 15, 2006. That evening, Simpson placed a loaded AR-15 semi-automatic assault rifle, which he referred to in his own language as his chopper, into the trunk of a friend's car before the group headed out for the night. The fact that he brought a loaded high-powered rifle to a social outing was established by the prosecution as central evidence of premeditation, or at least of a standing readiness for violence that he carried with him routinely. The group drove to a house party first, and then proceeded to a nightclub in northwest Oklahoma City called Fritz's. At the club, Simpson walked past a group of 3 young men, Glenn Palmer, Anthony Jones, and London Johnson, who were best friends spending a night out together. One or more of them made a comment about the Chicago Cubs baseball cap Simpson was wearing. The comment was, by most accounts, a minor taunt, the kind of thoughtless remark that passes between strangers in crowded places. Simpson walked away initially. Then he returned to the group. He told them he was going to chop them, using his word for his rifle, making clear in those words that there was a weapon nearby, and that he was considering using it. He walked away a second time. Then, in what witnesses and court records described as a gesture of attempted de-escalation, he came back a third time and extended his hand to Glenn Palmer, saying, in the courtroom language used to reconstruct the moment, "We cool." Palmer, apparently not accepting the peace offering and still angry about the earlier threat, punched Simpson in the mouth and knocked him to the floor. Simpson and his companions left the club. At a nearby gas station, Simpson encountered Palmer, Jones, and London Johnson again. The 3 men had left the club in Palmer's car and stopped at the same gas station. Whether this was coincidence or deliberate pursuit was contested at trial and in appeals. Simpson's attorneys argued that he genuinely believed, given the threat he had just made and the punch he had received, that the 3 men were following him with the intent to kill him, and that his perception of imminent danger, mediated through his PTSD and his history of having actually been shot in a drive-by in New Orleans, drove what came next. The prosecution argued that Simpson had a loaded assault rifle already in the trunk of his car, that the encounter at the gas station was a coincidence seized upon as an opportunity, and that what followed was a deliberate execution of 2 young men who had embarrassed him. The physical sequence of events, which was established through eyewitness testimony, forensic evidence, and the subsequent trial, was not in meaningful dispute. Simpson retrieved the AR-15 from the trunk, pointed it out of the car window, and fired approximately 20 rounds into Palmer's vehicle. Both Glenn Palmer and Anthony Jones were struck multiple times and died. London Johnson, the 3rd man in the car, was wounded but survived. He would later become one of the prosecution's key witnesses at trial. The investigation that followed moved quickly. Witnesses, physical evidence at the gas station, and the trajectory of the investigation led authorities to Simpson and his companions. 2 other men who had been in the car with Simpson on the night of the shootings ultimately made plea agreements with prosecutors in exchange for cooperation, receiving sentences of 20 years in prison rather than facing capital charges. Their cooperation, combined with London Johnson's eyewitness testimony and the physical evidence, built a comprehensive case against Simpson. He was arrested, charged with 2 counts of first-degree murder, and tried in Oklahoma County in 2007. The jury heard the full account of the night, including the nightclub confrontation, the gas station encounter, the retrieval of the AR-15, and the approximately 20 rounds fired into Palmer's vehicle. A jury convicted Simpson on both counts of first-degree murder and related charges. He received 2 death sentences, one for each murder. He was 26 years old. Simpson spent the next 19 years on death row at the Oklahoma State Penitentiary, and during those years, he underwent a transformation that his attorneys, his spiritual advisors, and those who worked closely with him described as genuine and profound. He became a published poet, writing verse that his legal team and advocates pointed to as evidence of the intellectual and emotional growth that had occurred behind bars. His legal team, who had worked with him since February 2011, described in public statements the extraordinary personal development they had witnessed in him over the course of their relationship. They said he had expressed remorse from the very first day he met with them, and had never wavered in his desire to convey his sorrow to those who had been harmed by his actions. He became, they argued, a man of empathy and reflection, someone who understood the weight of what he had done and carried it consciously. In 2019, the United States Supreme Court declined to consider an appeal that had argued his original trial attorney provided ineffective assistance during the punishment phase of proceedings. That door closed, and subsequent appeals pursued through the federal courts were similarly denied. By January 2026, as his execution date approached, Simpson and his legal team made a final push for clemency before the Oklahoma Pardon and Parole Board. That clemency hearing, held on January 15, 2026, exactly 20 years to the day after the murders, was emotionally charged on all sides. Simpson appeared before the board and spoke directly, and without equivocation about what he had done. He told the board, "I apologize for murdering your sons. I don't make any excuses. I don't blame others, and they didn't deserve what happened to them." He told them he was ashamed of being a murderer. He said he was not a monster, though he acknowledged that the families of his victims had every reason to see him as one. His defense attorney, Emma Rolls, argued to the board that Simpson was a deeply flawed man who had caused immense pain, who took responsibility for killing 2 people and for psychologically scarring a third, and that the death penalty was supposed to be reserved for the worst of the worst, which she argued he did not represent. Members of the victims' families also addressed the board. Palmer's sister, Crystal Allison, wrote in a letter to the panel asking whether she believed a man who had made the choice to end 2 lives should be allowed to live out his own behind bars, and made clear that she supported the execution. The 5-member Pardon and Parole Board voted narrowly to deny clemency. On the evening of February 11, 2026, the United States Supreme Court rejected a late appeal to block the execution without comment. On the morning of February 12, 2026, Kendrick Simpson was prepared for execution at the Oklahoma State Penitentiary. He had requested a final meal of classic fast food, a detail that attracted its own degree of media attention. His spiritual advisor, the Reverend Don Heath, was present in the execution chamber, where he read scripture as the proceedings took place. Simpson's family and members of his legal team were among the witnesses. Across the glass partition, family members of Anthony Jones and Glenn Palmer watched. When the warden asked Simpson for his final statement, he directed his words entirely toward the people on his side of the glass, naming the individuals who had come to be present and expressing love and gratitude. He said, "Love y'all, thank y'all for being here to support me." That's it. He said nothing to the families of the men he had killed. He said nothing to the memory of Glenn Palmer or Anthony Jones. He said nothing to London Johnson, who had survived the shooting and testified against him. The decision to use his final words exclusively to address his own supporters was noticed and felt by those on the other side of the glass. Crystal Allison, Palmer's sister, who had watched the execution, emerged from the prison to speak to reporters and described what she had seen with a simmering, 20-year weight of a grief that had never fully processed. She said, "The same smile that had been tormenting me for 20 years. He still smiled, that same smile laying on his deathbed." A doctor entered the chamber approximately 5 minutes after the drugs began to flow and declared Simpson unconscious. The execution lasted approximately 12 minutes. At 10:19 in the morning on February 12, 2026, Kendrick Antonio Simpson was pronounced dead. He was 45 years old. Glenn Palmer had been 20. Anthony Jones had been 19. They had gone to Fritzy's nightclub in Oklahoma City on a January night, and they had made a comment about a baseball cap, and they had never come home. Number 8, Jeffrey Lee. A jury voted for life. A judge overruled them, and nearly 30 years later the Supreme Court stopped the execution at the last hour. Jeffrey Lee was 21 years old on December 12, 1998, when he walked into Jimmy's pawn shop in Orrville, a small rural town in Dallas County, Alabama, and committed a robbery that ended in 2 deaths and launched a legal odyssey that would stretch across nearly 3 decades and produce, on June 11, 2026, one of the most dramatic last-minute legal interventions in modern American capital punishment history. Lee, who had grown up in chronic poverty and could not afford his own legal representation, had entered the pawn shop that day under circumstances established in detail at trial. According to court documents, he had come in earlier that day and asked the woman working the counter, Helen King, to show him wedding rings that were available for sale. She did. After looking at them, Lee told King that he did not have enough money to purchase anything but that he would return once he had obtained the funds. He left. Then he came back. This time he was armed with a shotgun, and this time he was not there to look at jewelry. What unfolded inside Jimmy's pawn shop in the next few minutes left 2 people dead and 1 survivor who survived only by pretending to be dead, and it set in motion a legal case that would become one of Alabama's most contested and constitutionally significant death penalty proceedings in the modern era. Jimmy Ellis was the owner of the pawn shop, a man who had built his business in the small community of Orrville, and whose name was on the sign above the door. Elaine Thompson was an employee, a woman who had come to work that day with no reason to expect that the day would be her last. Helen King was also there, working the shop, the same woman who had shown Lee the wedding rings earlier. When Lee entered with a shotgun, he shot all 3 of them. He shot Jimmy Ellis in the arm and then, fatally, in the chest. He shot Elaine Thompson in the face. He shot Helen King in the hand. King, wounded and bleeding, made a decision in that moment that saved her life. She pretended to be dead, lying still on the floor of the pawn shop while Lee attempted to force open the cash register and rob the store. Her stillness convinced him she posed no threat. He eventually left. King survived. Ellis and Thompson did not. Investigators arrived at the scene, documented the crime, and identified Lee as the perpetrator. He was arrested, charged with 2 counts of capital murder in connection with the deaths of Ellis and Thompson, and charged separately with the attempted murder of Helen King. The community of Dallas County, in Alabama's Black Belt, a region with a long and painful history of racial injustice and structural inequality, was the backdrop for the prosecution that followed. Lee, who is black, was tried before a jury drawn from a pool in which, according to later legal challenges, the prosecutor had used all 21 of his peremptory strikes against black potential jurors, a pattern that advocates argued reflected the kind of racially discriminatory jury selection practices that federal courts have repeatedly found unconstitutional under the Supreme Court's Batson framework. The trial took place in 2000 and resulted in a conviction on all charges. Lee was found guilty of the capital murders of Jimmy Ellis and Elaine Thompson, and convicted of the attempted murder of Helen King, for which he received a life sentence. Then came the sentencing phase for the capital charges, and what happened in that sentencing phase would define the legal and moral controversy of Jeffrey Lee's case for the next quarter century. Under Alabama law at the time, capital cases required a jury to make a sentencing recommendation, but the final decision on whether to impose death or life without parole rested with the trial judge, who had the power to override the jury's recommendation in either direction. This practice, known as judicial override, was unique to Alabama among American states, and was deeply controversial from its inception. At Lee's sentencing proceeding in 2000, the jury deliberated and voted 7-5 in favor of life imprisonment without the possibility of parole. 7 jurors looked at the evidence, considered the crime, and concluded that Jeffrey Lee should spend the rest of his life in prison, but should not be executed. 5 disagreed. The majority recommendation was life. The trial judge, exercising the judicial override authority granted by Alabama law, looked at that 7-5 verdict in favor of life and overruled it, imposing a sentence of death. One of the jurors, who had been among the 7 voting for life, spoke to reporters decades later and described the moment they learned the judge had overturned the jury's recommendation as devastating. That juror told CNN it was their first time realizing they had wasted their time serving on a jury. The override was challenged, upheld, challenged again, and upheld again through years of appeals. In 2017, the Alabama legislature itself acknowledged what legal scholars and advocates had been arguing for years. The practice of judicial override was indefensible. Alabama abolished it that year, establishing that from that point forward, only a unanimous jury recommendation of death could result in a death sentence, and that no judge could override a jury's choice of life. The reform came too late for Jeffrey Lee, whose sentence had already been imposed, and whose appeals in state courts had already run their course. The new law did not apply retroactively. Lee spent the years that followed his conviction and sentencing working through every available avenue of appeal. He challenged the racial composition of the jury pool, the constitutionality of the judicial override, the effectiveness of his trial counsel, and various other procedural and substantive grounds. He also, over the years, came to terms with what he had done in a way that he expressed in a 2026 phone interview with CNN, in which he said it had taken him years to face the fact that he had killed people, and that even now it was hard for him to accept that he had been capable of something like that. His words suggested a man wrestling genuinely with the weight of 2 lives, and his attorneys portrayed him not as a person who minimized what he had done, but as one who had lived with it in the most painful way available to him, behind bars, without the ability to make any of it right. Alabama Attorney General Steve Marshall, speaking for the state, directed his words toward the victims. Marshall told reporters he thought of the hopes and dreams of Jimmy Ellis and Elaine Thompson, the futures and the lives with their families that had been taken from them by Lee's premeditated and cruel actions, and said the courts had repeatedly upheld Lee's conviction and sentence. Both things were true at once. The crime had been real and devastating, and the legal path to the execution had been profoundly contested. The final chapter of Lee's case in the months before his scheduled June 11, 2026, execution introduced an entirely new constitutional dimension that had nothing to do with the original crime or the judicial override, but with the method Alabama intended to use to carry out the sentence. Alabama had adopted nitrogen hypoxia as an alternative execution method, making it one of only a handful of states to use the procedure, which requires the condemned person to breathe pure nitrogen gas through an industrial-grade mask until they lose consciousness and die from oxygen deprivation. Alabama had carried out prior nitrogen executions, and those earlier cases had generated legal challenges that produced conflicting lower court rulings. In Lee's case, he He had actually elected nitrogen hypoxia over lethal injection back in 2018, years before Alabama had developed a specific protocol for the method. By the time the protocol was developed and his execution approached, Lee's attorneys challenged it as constitutionally defective, arguing that it would cause intolerable suffering. He simultaneously proposed an alternative, execution by firing squad, a method not currently authorized under Alabama law but one his attorneys argued was feasible, readily implemented, and would significantly reduce the risk of the kind of prolonged suffering they said nitrogen hypoxia would inflict. The litigation that followed was rapid, consequential, and unfolded in real time in the days immediately before June 11, 2026. A United States District Judge, Emily Marks, initially ruled in May that Alabama's nitrogen protocol was constitutional. But the 11th Circuit Court of Appeals reversed that ruling by a 2-to-1 vote, issuing a decision that found the 3 minutes it could take for an inmate to lose awareness under the nitrogen protocol to be an intolerable time frame given the suffering that would likely take place, and that constitutionally speaking, this was impermissible. Number 9. Krista Pike, the youngest woman sentenced to death in modern American history, and a murder so savage that the groundskeeper who found the body could not initially tell it was human. Krista Gale Pike was born prematurely on March 10, 1976, in Beckley, West Virginia, the first child of Carissa Hansen and Emil Glenn Pike, two people whose relationship was defined from the beginning by instability and dysfunction. They had married, divorced after Hansen was found to have been unfaithful, and then remarried, a cycle of rupture and reconciliation that created a home environment for Krista and her older half-sister that was anything but stable. Her parents ultimately separated again, and Krista's early years were marked by the kind of domestic upheaval that courts and psychologists would later point to as formative context for the person she became. She was diagnosed, after her conviction, with bipolar disorder and post-traumatic stress disorder, conditions that her attorneys argued had gone undetected and untreated throughout her adolescence, and that had contributed to the volatile, impulsive, and ultimately homicidal behavior she displayed at 18 years old. By the time Krista Pike arrived at the Knoxville Job Corps Center in Tennessee in late 1994, she was a young woman carrying considerable psychological baggage, entering an environment designed to help troubled teenagers find vocational direction, and forming attachments and resentments with the intensity of someone whose emotional regulation had always been fragile. One of those attachments was to a 17-year-old boy named Tadrill Shipp. One of those resentments was directed at a 19-year-old girl named Colleen Slimmer. And what grew from the collision of those two relationships would produce, on a rainy night in January 1995, one of the most brutal murders in Tennessee history, a crime so savage in its deliberateness, and so grotesque in its aftermath, that it would place Krista Pike on death row at 20 years old, making her the youngest woman sentenced to death in the United States in the modern era, and leave her there for 3 decades, until a September 30, 2026, execution date made her the first woman scheduled to be executed in Tennessee in more than 200 years. Colleen Slimmer was 19 years old in January 1995, a young woman from Florida, who had enrolled in the Knoxville Job Corps Center seeking vocational training in computers, having chosen Knoxville because the Jacksonville Center did not offer the program she wanted. She had come to Tennessee to build a future for herself, and she had told her mother, May Martinez, about problems she was having with another student named Krista Pike. Slimmer's family has always maintained that she had no romantic interest in Tadrill Shipp, that she was not trying to steal Pike's boyfriend, that the entire premise of Pike's jealousy was a fiction. But Krista Pike had decided otherwise. She had begun a relationship with Shipp, who was a year younger than she was, after they met at the Job Corps Center, and the two of them had developed a shared interest in the occult and devil worship that would manifest in the most literal and horrifying way imaginable on the night they killed Colleen Slimmer. Pike's jealousy of Slimmer had been building for weeks, and on January 11, 1995, the day before the murder, Pike explicitly told a dormitory housemate named Kim Iloilo that she intended to kill Slimmer, a statement that established the premeditation prosecutors would later argue was central to the case against her. The following day, January 12, 1995, Pike asked her friend Shadala Peterson for a box cutter. Peterson, 18 years old, handed it over. The plan was set. That evening, Pike, Shipp, and Peterson approached Colleen Slimmer with an offer of peace and marijuana, dangling the promise of a reconciliation and a social outing to convince Slimmer to go with them. The four of them signed out of the dormitory log together that night, a fact that would later be one of the most damning pieces of evidence in the investigation, as the log showed all four names leaving together, and only 3 names returning. They walked from the Job Corps Center on Dale Avenue along the Cumberland Avenue Strip and then through Tyson Park, cutting across a large field toward a secluded, abandoned steam plant on the University of Tennessee agricultural campus, well away from the lights and the paths and the people. Once they reached that isolated spot, Slimmer was surrounded. What followed was not a sudden eruption of violence but a prolonged, deliberate, and sadistic assault that investigators and witnesses later estimated lasted between 30 minutes and an hour. It was not a crime of passion. It was a crime of pleasure, of dominance, of cruelty indulged without restraint. Pike turned on Slimmer suddenly, accusing her of trying to steal Shipp, cursing her and taunting her as Slimmer stood there in the cold and the wet, trapped by the circumstances of how she had been brought to that place. Pike slashed Slimmer across her back, her chest, and her neck with the box cutter Peterson had provided. When Slimmer tried to cry out for help, Pike pulled the hairband from her own hair and jammed it into Slimmer's mouth to silence her. Shipp participated in the attack while Peterson stood at a distance acting as a lookout, watching for anyone who might approach. Slimmer at one point attempted to run, but Shipp tripped her, throwing her back to the ground. Then, while Slimmer lay wounded and bleeding but still alive, Pike and Shipp did something that shocked even seasoned law enforcement veterans, who would later investigate the case. They carved a pentagram into Slimmer's chest. They attempted to carve another into her forehead. Testimony at trial quoted participants saying that the pentagram was a trapdoor to release the soul to Satan. Pike, by her own account delivered to investigators after the fact, was frustrated during this period of the assault because Slimmer would not die. The attack had been going on for what felt to Pike like too long, and her victim was still clinging to life. Finally, Pike picked up a large chunk of asphalt from the pathway and began striking Colleen Slimmer in the head with it, delivering blow after blow until Slimmer's skull was fractured and she lay dying on the ground. In the moments before Slimmer lost consciousness for the final time, Pike leaned over her and asked, in the words she would later recount to investigators, "Colleen, do you know who's doing this to you?" Then Slimmer was dead. Pike reached down, broke off a small piece of Colleen Slimmer's skull, and put it in the pocket of her jacket. She then cut Slimmer's throat. The three returned to the Job Corps Center. Pike did not discard what she had taken. The following morning, she carried the fragment of Colleen Slimmer's skull around in a napkin and showed it to other students at the center, bragging about what she had done. A groundskeeper from the University of Tennessee discovered the body on the agricultural campus pathway. He later testified that the remains were so badly disfigured that he initially could not tell that the object he was looking at was a human corpse. Investigators arrived and began working the crime scene, and within 36 hours of the murder, all three participants had been arrested. The signed dormitory log and the skull fragment in Pike's possession were among the most incriminating pieces of physical evidence. Shipp gave a detailed statement to Knoxville Police Department investigator York in which he described the events of the night, a statement that named all participants and established the sequence of events in comprehensive detail. The investigation was swift and thorough, and the evidence against Pike was overwhelming. She was charged with first-degree murder, conspiracy to commit first-degree murder, and attempted first-degree murder for the attack on Slemmer, during which a second victim, identified in later records as Patricia Jones in a separate 2001 incident on death row, was also added to her criminal history. Shadala Peterson, who had acted as lookout and who had provided the box cutter, pleaded guilty to second-degree murder in exchange for her testimony against Pike and Shipp, and received a reduced sentence. Tatterall Shipp, who had been 17 years old at the time of the murder, was legally ineligible for the death penalty under Tennessee law due to his age, and received a life sentence with the possibility of parole, a sentence that would eventually make him eligible for parole hearings decades later, a disparity between his outcome and Pike's that would become one of the central arguments in her subsequent appeals. Krista Pike's trial took place in 1996, and the details presented were comprehensive and devastating. Deputy District Attorney General Steve Sword argued to the jury that the crime was not the result of passion or chance, but of calculated brutality, demonstrating what the law described as depravity of mind. The jury heard the testimony about the box cutter, the pentagram carvings, the silencing of the victim with a hairband, the asphalt blows, the final question asked over a dying girl, and the fragment of skull carried around as a trophy. They convicted Krista Pike of first-degree murder and conspiracy to commit first-degree murder on March 22, 1996. On March 30, 1996, she was sentenced to death. She was 20 years old, making her the youngest woman sentenced to death in the United States in the post-Furman era of modern capital punishment. She was transferred to what would eventually become the Deborah K. Johnson Rehabilitation Center in Nashville, where she remains incarcerated to this day. The 3 decades that followed her conviction were marked by repeated legal challenges, all of which were ultimately unsuccessful, and by at least one additional serious criminal incident. In August 2001, while incarcerated, Pike was involved in an attack on another prisoner, Patricia Jones, in which she used a shoestring as a weapon in what prosecutors characterized as an attempted murder. She was convicted of attempted first-degree murder for that assault and received additional sentencing. Her attorneys repeatedly raised claims of inadequate representation at her original trial, arguing that her defense counsel had failed to present sufficient mitigating evidence about her troubled upbringing, her documented mental health conditions, and the circumstances of her childhood. Both state and federal courts consistently upheld the conviction and sentence, finding that the aggravating factors of the crime, its planning, its duration, its deliberateness, and its extraordinary cruelty, outweighed the mitigating factors presented. The Death Penalty Information Center noted that if her September 30, 2026, execution proceeds, she will be the only person executed in Tennessee for a crime committed at age 18, 19, or 20 in the modern death penalty era, a distinction that her attorneys argue makes her case constitutionally anomalous given the evolving standards of decency that the Supreme Court has applied to young defendants in cases like Roper v. Simmons, which abolished the death penalty for those under 18 at the time of their crime. Her attorneys have argued that a person who was 18 is barely different, neurologically or developmentally, from a person who was 17, and that the bright line cutoff produces arbitrary outcomes. In January 2026, with the September 30th execution date formally set by the Tennessee Supreme Court, Pike's legal team filed a lawsuit in Davidson County Chancery Court raising a new set of challenges. The lawsuit argued on 3 grounds. First, that given Pike's unique medical conditions, the state would be unable to prevent what the attorneys characterized as a tortuous execution. Second, that Tennessee's current lethal injection protocol using pentobarbital, which had been updated in December 2024, violated her constitutional rights. And third, that the method conflicted with her religious beliefs. The state responded in March 2026, contending that Pike had not sufficiently demonstrated that the execution method would violate her constitutional rights. Pike, who was born in West Virginia and grew up in North Carolina before coming to Tennessee, also has the option under state law of electing electrocution as an alternative method, applicable to inmates whose crimes were committed before January 1, 1999. Her attorneys continued pressing all available legal arguments as the execution date approached. Colleen Slemmer's mother, Mae Martinez, who had spent 3 decades waiting for the justice system to complete its work, told reporters in the months before the scheduled execution, "I would like Tennessee to hear my plea and finally end this after 30 years." The Job Corps Center on Dale Avenue in Knoxville, where Colleen Slemmer had come to build a future, closed in the aftermath of her murder, its association with the killing too heavy a weight for the program to bear. Colleen Slemmer had wanted to learn computers and find a path forward. She had come to Tennessee for an opportunity, and found instead a young woman whose jealousy had hardened into something monstrous, a piece of asphalt, and a night on the agricultural campus from which she never walked back. Number 10. John Allen Rubio, the Brownsville father who beheaded his 3 children, claimed the devil made him do it, and has spent 23 years trying to convince the courts he is too insane to die. On March 11, 2003, in Brownsville, Texas, 3 children were murdered inside their home by their parents. Their names were Julissa Quesada, 3 years old, John E. Rubio, 1 year old, and Mary Jane Rubio, 2 months old. John Allen Rubio was sentenced to death for decapitating his infant daughter Jane Rubio and 2 stepchildren with his common-law wife, Angela Camacho. The crime, which Cameron County District Attorney Louis Sines has described as the most horrific case in the history of Cameron County, has left an open wound on the community of Brownsville that has never fully healed, and which the home where the killings occurred has since been destroyed and replaced with a community garden and park with 3 trees as a permanent memorial to the children who died there. John Allen Rubio was 45 years old as of 2026 and is scheduled to be executed on November 12, 2026. He has spent 23 years on death row, insisting, through a revolving sequence of defenses and mental health arguments, that he did not act alone, that he was not in control of his faculties, and in the most extraordinary claim of all, that the children he killed were possessed by demonic forces. The courts twice over have rejected every version of that argument. The community of Brownsville, which has spent more than 2 decades watching appeals extend and delay the sentence, is waiting. That plus 4. John Allen Rubio grew up in Brownsville, Texas, the southernmost city of the Rio Grande Valley, sitting at the southern tip of Texas directly on the border with Mexico. It is a city of working-class families, a border community shaped by the rhythms of trade, agriculture, and immigration, a place where extended families tend to live in close proximity and where community ties run deep. Rubio, by the time he reached his late 20s, was living in a small apartment on the corner of 8th Street and Tyler Street in Brownsville with his common-law wife, Angela Camacho, and their 3 young children. 2 of the children, Julissa and John E. Rubio, were Camacho's children from a prior relationship and were Rubio's stepchildren. The youngest, 2-month-old Mary Jane Rubio, was Rubio's biological daughter. The circumstances of their household in early March 2003 have never been established with clinical precision in terms of what specific psychological state Rubio was in during the days immediately before the murders. What is known is that on the night of March 11, 2003, the 3 children, the oldest of whom was 3 years old and the youngest of whom had been alive for only 2 months, were killed inside the family apartment in a manner of violence so extreme that the first officer to enter the scene, retired Brownsville Police Department Sergeant Jimmy Manrique, would say more than 2 decades later that he would never forget it for as long as he lived. Manrique was the sergeant on duty that night. When he walked into the home, He saw the decapitated body of a child on the bed. The responding officers had been weighed down by a family member. He just said there was a decapitated baby in the room, Manrique recalled, describing the moment of the call. The scene officers discovered inside the apartment on 8th and Tyler was one of the most disturbing in the memory of anyone who worked law enforcement in the Rio Grande Valley. All 3 children had been decapitated. Their heads had been placed in plastic bags. Court documents read that Rubio stated they placed the children's heads in plastic bags, had sex, and then cleaned up the apartment. The apartment had been partially cleaned by the time officers arrived, but the evidence of what had taken place inside it could not be erased by cleaning. The 3 children, ranging in age from 3 years to 2 months, had been killed by their own parents in their own home, and the 2 adults had then used the aftermath of that violence as an occasion for sexual intimacy before attempting to restore some semblance of normalcy to the physical environment. It was a sequence of behavior so disconnected from ordinary human response to violence, even violence one has committed, that it became central to the defense's later argument that Rubio was in a dissociative, psychotic, or otherwise mentally incompetent state at the time of the killings. Gulf News Plus 2, when police arrived, Rubio gave himself up for arrest. Rubio told police he believed the children were possessed and killed them. That claim, delivered to officers in the immediate aftermath of the murders, established the central narrative that the defense would attempt to construct and maintain across 2 trials and more than 2 decades of appeals. Rubio did not deny killing the children. He never claimed that someone else had done it, or that he had not been present. His defense was not one of factual innocence, but of mental state, that he had been in the grip of a psychotic episode, that he had genuinely believed the children were demonically possessed, and that this delusion rendered him incapable of forming the intent required for capital murder. Camacho gave conflicting reports about what took place, but overall confirmed Rubio's account. She had been a participant in what happened that night, and her own culpability was the subject of a separate legal proceeding. Camacho was found guilty in 2005 and is currently serving a life sentence. She received 3 concurrent life sentences rather than a death sentence, a disparity between the 2 participants that reflected the prosecution's assessment of their relative roles in the killings, with Rubio identified as the primary actor and the person who physically carried out the decapitations. AOL Plus 2 Rubio's first trial took place in 2003 and resulted in a conviction for capital murder and a death sentence. That conviction was subsequently overturned by an appeals court in 2007, not on grounds of factual innocence or insufficient evidence of the crime itself, but on legal procedural grounds relating to the conduct of the trial. The overturning of the conviction meant that Rubio was returned to Cameron County for a new trial, a development that extended the legal proceedings significantly and required the community of Brownsville to relive the events of March 11, 2003, through a new round of courtroom testimony, evidence presentation, and victim impact statements. The second trial proceeded before a new jury that heard the comprehensive account of what had happened in the apartment on 8th and Tyler Street. The defense team, in preparing for the second trial, had pursued the demonic possession angle with unusual determination. Rubio's defense attorney, Nat Perez Jr., told Channel 5 News that a doctor found Rubio incompetent at the time of the murders. Perez says that ahead of the second trial, the defense team approached a local bishop to see if he would testify about demonic possession within the Catholic faith. The bishop declined to provide that testimony. The defense argument that Rubio had been in the grip of a genuine delusion about possession was heard by the second jury and weighed against the prosecution's account of a man who knew precisely what he was doing, who had afterward engaged in deliberate acts of cleaning and concealment, and who had demonstrated through his post-crime behavior the capacity for intentional action rather than the helplessness of someone in a genuine psychotic break. The second jury convicted Rubio of capital murder. Rubio was sentenced to death in 2010 following the conclusion of the second trial, meaning he had now been convicted of capital murder twice by two separate juries and sentenced to death twice by two separate courts. World Socialist website the legal proceedings that followed the second death sentence consumed the next 16 years and produced a comprehensive record of appeals through the Texas state court system, the federal district courts, the Fifth Circuit Court of Appeals, and ultimately the United States Supreme Court. Every appeal was denied. In May 2025, Rubio's death row appeal was rejected again by the U.S. Court of Appeals for the Fifth Circuit. On January 12, 2026, the U.S. Supreme Court rejected his appeal one final time. That Supreme Court denial cleared the way for the state to seek an execution date, and in February 2026, the Texas Department of Criminal Justice formally set November 12, 2026, as the date for Rubio's execution. Cameron County District Attorney Louis Saenz, who had not been the district attorney at the time of the original trial, but who had inherited the case and its years of appeals, responded publicly to the setting of the execution date with words that reflected the cumulative exhaustion and resolve of everyone in Cameron County who had been fighting to see the sentence carried out. Saenz confirmed he will witness the inmate's execution. He said, "I can tell you that I will be there. I can tell you that I have asked to be allowed to witness the execution. Because I want to witness it, I want to come back and tell the community, it's done. Justice has been served." ALAL retired Sergeant Jimmy Manrique, who had been the first officer into the apartment on the night of March 11, 2003, and who had carried the weight of what he saw there for more than 2 decades, also spoke publicly in the months before the scheduled execution. Manrique recalls Rubio attempting reverse psychology in the courtroom, claiming he never saw remorse or tears from Rubio. He said, "No, absolutely not from John. He deserves the death sentence, and everyone knows it. For me personally, it has been haunting, but I have a purpose, and that's justice for those 3 kids." The community of Brownsville had been carrying this case for 23 years, and the weight of it had never lightened. The home on 8th and Tyler Street, where 3 children under the age of 4 had been decapitated in the night by the people who were supposed to protect them, no longer stood. The city had torn it down. In its place stood a small park with 3 trees, one for each child, each decorated at memorial ceremonies with a single ribbon. The park was a physical acknowledgement by the community that the ground where the apartment had stood was not simply a piece of real estate, but a place where something irreversible had happened, where 3 lives had ended before they had. But the road to November 12, 2026, was not yet clear. A newly filed 44-page motion asks the court to halt the execution and order further evaluation. Rubio's legal team had filed that motion at the end of April 2026, arguing once again, in the most recent iteration of a claim that had followed him since 2003, that he was not competent to be executed. The legal standard for competency to be executed, established by the Supreme Court in Ford v. Wainwright in 1986, requires that a condemned person have a rational understanding of why they are being executed and what the execution means. Rubio's attorneys argued in the 44-page motion that he lacked that rational understanding due to ongoing and severe mental illness, and that executing someone in that condition was unconstitutional. The state has until June 30, 2026, to respond to that motion. The court will then set a hearing for any time after July 1, 2026. District Attorney Saenz, who had heard versions of the mental health and incompetency argument from Rubio's legal team for years, expressed both confidence and frustration. He said, "I expect to prevail at that hearing, but that means that they're going to appeal, and again here comes the delay. It's just very frustrating." He had previously said of the full history of appeals in the case, the argument was basically that he's incompetent to stand trial, that he was insane, that he was possessed, the devil made him do it, just about anything you can think of. Those were rejected, not once but twice. Fox News Plus 3 Rubio himself, still on death row at the Polunsky unit in Livingston, Texas, gave an interview in 2026 in which he expressed remorse for the children's deaths, while simultaneously maintaining the framework of mental illness and supernatural belief that had defined his defense since 2003. He said every day he missed them. Whether that remorse was genuine, or whether it was the performance of a man who had spent 23 years crafting whatever narrative gave him the best chance of avoiding the lethal injection chamber, was a question that only Rubio himself could fully answer, and a question that the courts had conclusively decided was not their concern. 2 juries had heard his explanations. 2 courts had sentenced him to death. The Supreme Court had denied his final appeal. The execution date was set. The district attorney had asked to witness it so he could return to his community and tell them that justice had finally been done. And in the small park on the corner of 8th Street and Tyler Street in Brownsville, 3 trees stood in the spot where an apartment building used to be, each one representing a child who had been alive at the beginning of March 2003 and dead by the end of it. Julissa Quesada had been 3 years old. John E. Rubio had been 1 year old. Mary Jane Rubio had been 2 months old. They had never had the chance to be anything other than young and small and entirely dependent on the adults who were supposed to keep them safe. On November 12, 2026, if the courts allow it, the last of those adults who failed them will receive the sentence that 2 juries decided they deserved.